Hello, everyone. Thank you for joining us today for this webinar about navigating the uncertainty of the COVID-19 environment and guidance specifically for the cannabis industry. While we'd all rather be together in person today, we're glad that you've been able to join us here for this webinar, and thank you very much for joining. My name is Jonathan Sherman, and I'm the co-chair of the Cassels Cannabis Group, and we're pleased to co-host this event with the CSE here today. Thank you very much to Rob Cook and his team, and to the CSE generally for sponsoring this event with us. In terms of the format of the event here today, we're going to have 4 separate panels. We're going to have 2 panelists on each of those 4 panels. Each panel will last 20 minutes and will provide some information about a variety of different topics that are relevant to participants in the cannabis industry. We'll have a short 5-minute break between panel number 2 and panel number 3 to make sure that people have an opportunity to use the washroom and not miss any of the content. A couple of initial notes. First, all of the information being provided today should not be considered legal advice. Please make sure to reach out to Cassels or your legal counsel if you have specific questions about the particulars of your circumstances, particularly given the challenging times that we're in today and the nuances of everyone's particular circumstances. In addition, I note that on the webcast, there is a question, an ability to ask questions through the chat box. Those questions will be filtered to me as the moderator of each of the panels, and we will try to address those as best as possible. And so without further ado, we'll move on to our first panel. I'd like to introduce Rob Cook, Senior VP, Market Development of the Canadian Securities Exchange, and Andrea Fitzgerald, Partner at Cassels in our securities practice, who will be joining for the first panel. So Andrea, why don't we start with you? The Canadian Securities Administrators have made a number of announcements that impact continuous disclosure obligations for public companies. Can you give some brief background about the blanket relief that's available for public companies in Canada?
Sure. Currently, the CSA has published a couple of different pieces on blanket relief for issuers during the COVID-19 crisis. One of which is to extend the filing deadlines for issuers to be able to file continuous disclosure documents such as financial statements, annual information forms, management discussion analysis, those type of continuous disclosure documents with a 45-day extension from the normal filing deadline that an issuer may have. And this is available until June 1st at the moment. The regulators have indicated when they put the relief out that it's possible it may be extended, but there's been no guidance at this point from them on whether they will in fact be extending it beyond the June 1st deadline at this point. But essentially what it allows is issuers who have a filing deadline coming up before June 1st can extend that filing deadline by a total of 45 days. And in order to do that, the requirement is that the issuer issue a press release before the initial deadline, so before the normal deadline that they would typically be filing, for example, their financial statements, if that's what we're talking about. And in that press release, they need to indicate what relief they're relying on. So if it's for filing an AIF or for filing financial statements, or maybe it's both, you've got to disclose that in the press release. You also have to disclose in your press release that management and other insiders are subject to insider trading policies and blackout periods that have been implemented by the company. And also you need to disclose the estimated filing timing that you anticipate being able to file the continuous disclosure document by, and also any material updates to your business that's occurred since your last financial statement filing. So once you have that press release out, then you're eligible to take advantage of the 45-day extension. The other requirement is that you must file another press release once the extension period starts, so essentially the day after your normal filing deadline. Within 30 days of that period, you have to file another press release just giving an update to the market as to whether there's any material business developments or confirming that there's been none in your business. And then if you continue not to have updated your continuous disclosure record and made that financial statement filing yet, for example, then 30 days after that press release, you have to issue another one, just giving another update to the market as to whether there's any material business developments in your business or confirming that there's been none. The one key consideration in relying on this exemption is that while you have the continuous disclosure document delay, you're not permitted to file any kind of prospectus. And so that would include things like a shelf prospectus, not just an offering prospectus, even non-offering prospectuses. And the reason being that the regulators consider your continuous disclosure record not to be completely up to date. And so they won't permit you to file that prospectus until your record is completely up to date and those filings have been made. The second portion of relief that's come out since that 45-day extension is the securities regulators and the stock exchanges as well have permitted certain extensions for AGM, for companies holding their AGMs. And so initially the TSX and the TSXV had come out with relief to allow issuers to waive the 6-month after year-end deadline, for example, for the TSX, and the 15-month following your last AGM in the case of TSXV issuers, to be able to have those issuers hold their AGMs at any point during 2020. So you could hold your 2020 AGM anytime between now and December 31st. The securities regulators then came out following that with relief to allow companies to delay the filings of their annual AGM materials, meaning your circular or your executive compensation disclosure that's required typically under securities laws to be filed within 140 days of year end if you're TSX, or if you're a non-venture issuer, I should say, and within 180 days if you're a venture issuer. And so the relief extends those deadlines to allow companies to be able to file their executive compensation disclosure. AGM circular is typically where it's included. Anytime, again, until December 31st to align with when you would be filing and mailing those materials in connection with a delayed AGM. In order to rely on that relief, again, the issuer has to issue a press release stating that it's relying on this relief, and also the press release has to go out ideally before the deadline for filing your exec comp disclosure, or as soon as practicable after that deadline if you miss that. And the other condition to relying on the relief is that you must file your financials and MD&A for your annual year end before you mail or before you file your AGM circular. So those have to be out to shareholders and available for viewing before you file your circular materials to hold your AGM. The additional relief around AGMs and the materials for filing that they've included in that is the annual request form that issuers typically send out with their AGM materials that essentially allow shareholders to choose whether they want to receive paper copies of financial statements and MD&A. The relief there is that companies can avoid sending that request form altogether, because it's a bit difficult these days in the midst of the crisis to gather up paper copies and start doing mailings. And so that relief is allowed to avoid sending that request form this year if you send your materials, meaning your annual financials and MD&A, to all your shareholders by December 31st of the year. Alternatively, if you've previously sent out a request and you're receiving requests back from shareholders to provide them with paper copies of the financials and MD&A, you're permitted to delay sending them until as soon as reasonably practicable. So typically the securities law deadline is you have to send them the paper financials and MD&A either 10 days after you file the applicable financials or within 10 days of receiving the request from them, but the relief allows you to be able to send it as soon as you practically can up to December 31st. I should mention too that the CSA has published frequently asked questions on all of this relief that they've put out. And so that's a useful thing for issuers to kind of see the type of questions that are coming up, because likely many issuers have had the same kind of questions, and the securities regulators are continuing to update that FAQ to give more guidance to issuers, and those FAQs can be found on the Securities Commission's websites for reference.
Perfect. Thank you, Andrea. And so, Rob, following the announcements from the securities regulators, has the CSE provided any other relief to listed issuers that should be noted?
The CSE requirements for listed companies for continuous disclosures, such as financial statements and MD&A, and information circulars for shareholder meetings, all of those things are governed by applicable corporate law and securities law and regulation. So the CSE has never adopted our own or published our own requirements that say, thou shalt file within this time period or hold your meeting within that time period, because those requirements are already there for public companies in Canada. So we did not need to provide any particular relief. What we did do was we published two notices, one on March the 20th and one on April the 6th. The first essentially explained what I just said, that the relief provided by the CSA and corporate law is equally applicable to CSE companies. The second notice that we published provided guidance on financial statement and management discussion and analysis disclosure, particularly regarding the impact of COVID-19. We suggested that companies that have already reported or are reporting on a period that ended prior to the imposition or the onset of the COVID crisis and the lockdown, consider whether there's subsequent event notes that might be appropriate, and also have discussions in their MD&A on potential impact on the company. So that was essentially what we did in terms of providing relief. The other thing that we did was we located 6 different service providers who could assist a company in conducting a virtual AGM, or what they call a hybrid AGM, which is part virtual. And we published that in a newsletter aimed at our listed companies. We gave them contacts at 6 different organizations. I believe 3 of them were transfer agents, and the other 3 were independent third parties. So that was the direct communication that we made with respect to the current COVID crisis.
Thanks very much, Rob. And is the CSE engaged in ongoing discussion with securities commissions at all? And should we expect any further announcements coming from the CSE, or is it largely going to be
not that we're aware of? No, the CSA really doesn't need to discuss with the stock exchanges. We each know what our respective responsibilities are, and I think they spend enough time talking to each other that they don't want to expand it to have to include exchanges as well. So, given that, we're not expecting anything in particular. Although we hope that as the COVID crisis is extended, that they will also extend relief where necessary and appropriate.
And so, Rob, what have you been hearing the last couple of months, whether it be from listed issuers and investors? What's the sentiment that you're hearing And is there anything that listed issuers are reaching out regularly that's been a common theme for you guys?
Well, surprisingly enough, it's been fairly positive. Although, I mean, some companies are obviously hurting, but we have had sort of an ongoing program of reaching out. We do keep track of what the companies are doing and try to keep in touch with them. And most of them are fairly positive. Some of them, however, are lacking financing, and so some of them are in more perilous circumstances than others. But most of them are adapting as best that they can. At the CSC, we started working from home just over 2 months ago, on March the 12th, and we've been reaching out ever since. We're now doing a lot of online activity. For well over a year, we created these podcast interviews called #Finance that are available through the homepage of our website. But we're also doing Instagram Live interviews. We have a YouTube channel called CSE TV, and we're adding content almost daily. Some of that content is just discussions with the CEOs of our listed companies, but a lot of it is also third-party experts. For example, we participated in webinars on Reg A plus financings in the United States, and ATM financings, also known as at-the-market financings, which are two things that a lot of people have become quite interested in, given the current circumstances. We're creating some forums with sector themes. We're actually currently in the middle of Cannabis Week, so this webinar fits right in. We're going to be doing one on esports later in May, one on psychedelics in June, and another on technology issuers in July. The psychedelics one is largely focused on the companies that are into research of psilocybin, and we actually have 6 companies that are involved in it in one way or another already. We have Instagram broadcasts from Vancouver every Wednesday. So at 4 p.m. today, there'll be a West Coast Wednesday production. So those are some of the things that we're doing. We've seen trading and listing activity both are fairly buoyant. So we haven't seen a drastic downturn, although in March, obviously, our index was crushed in terms of the index level, but it's recovered quite a bit since it bottomed out around March 23, and it's up about 50% since it hit bottom, led by the cannabis sector. Particularly the large multi-state operators in the United States, I think have led the way. Financing activity across the board has been reduced, but we are still seeing it frequently in the mining exploration sector. Gold is very popular, and everybody knows why. So there's been a lot of activity there. We've also listed 20 new companies since the beginning of March. So that's been fairly active. And we are currently developing, with discussions with the Ontario Securities Commission and the British Columbia Securities Commission, we're developing a senior listing tier to create a listing venue for non-venture companies on the CSC. And we hope that comes out in the next month or two. So the other thing that we're seeing a lot, I think because of the reduced finance activity. We're getting more inquiries from companies that are looking for a public shell because they're hoping to go public by way of a reverse takeover. We're also seeing more inquiries from companies listed on other stock exchanges in Canada that are interested in switching to the CSE. So that has increased a fair bit. So that's really what's happening at the CSE today. It's been surprisingly active and relatively upbeat.
Perfect. Well, thank you. It certainly sounds like things have been busy on your end.
Yeah.
Pivoting for a moment, just a question we got from the audience. So, Andrea, just a specific question about whether an AIF needs to be filed before AGM meeting materials are filed on CEDAR.
No, under the current relief that the CSA has put out, the only requirement is to file your annual financials and MD&A ahead of the AGM materials or your circular, not your AIF. Perfect,
thank you. And then just cognizant of time, wanted to just kind of hit on one final point here, Andrea. We've obviously talked about some of the blanket relief and some of the TSX, TSXV relief on some of their rules. But what else should issuers be considering from a corporate law perspective as well? And have there been any developments on that front?
Yeah, there have been, and that's a good point, Jonathan, because despite all this relief that's coming from the securities commissions and the stock exchanges, issuers are still required to abide by their corporate law statutes. So the OBCA or CBCA or BC Corporations Act, depending on where you're formed. And there hasn't been as much relief granted from the governments at the corporate law level. The OBCA, the Ontario government, has granted some relief for OBCA companies where the typical timing for AGMs is within 15 months of your previous AGM or 18 months after being first formed as a company. And they've waived those timing requirements to align with what the CSA and the stock exchanges have allowed to allow issuers to hold their AGM at any time during 2020 up to December 31st. And they've also waived the corporate law requirement to present the financial statements to shareholders within 6 months of year end to align with that. So you can do your filings and mailings and hold your AGM at any point during 2020. The other corporate acts have not followed suit. And so corporate acts like BC Act, the Alberta Act, or even the federal act, so CBCA companies haven't been granted the same relief by the government. And so in those cases, to be able to delay your AGM past the standard 15-month timeline, you would need to actually seek a court order to be able to do so. So a little more work involved there for companies outside of the OBCA companies. The additional relief that has been granted is from the BC government. So even though the timing requirement for holding your AGM is the same as what the corporate law statute currently says, the BC government has provided relief to BC companies who normally have to hold their AGMs in a physical location in British Columbia to now allow them to be able to hold virtual meetings, and it doesn't have to be in a physical location. So that's the relief that BC incorporated companies have been given. And the other relief that the OBCA companies have is the ability. Right now, the corporate law statutes, including the OBCA and Alberta and also the CBCA, talk about being able to hold a meeting telephonically or by other electronic means, provided that the bylaws of the company permit that. The OBCA companies have the relief now to be able to hold a virtual AGM regardless of whether their bylaws actually permit it. And so that's an additional piece of relief for OBCA companies. The other statutes have not followed suit. And so if you're incorporated under any other statute, your bylaws still have to provide the ability to hold a virtual AGM. And one potential way around that, if you have a situation where you need to hold a virtual AGM and your bylaw doesn't permit it, is you're able to have the directors make an amendment to the bylaw to provide for that, which would be effective up until your next AGM, when you have to ask your shareholders to ratify and confirm it. So that's one potential way to deal with trying to hold a virtual AGM if your bylaws don't actually permit. So all that to be said, it's, it seems to be a little more useful from the TSX company perspective, because you've got the waiver of within the 6 months, but you by corporate law may still have to hold it within the 15 months of your last AGM. So it may give you a bit of a longer runway, but unfortunately, even with the securities law relief, because of the corporate law statutes, you don't have quite as much flexibility to delay the AGM that much unless you go for court orders if you're outside of the OVCA.
Perfect. Well, thank you both very much for all of your insights. Unfortunately, we're out of time on this panel, but thank you, Rob, and thank you, Andrea, for making time to share your insights. And if anyone has any questions, by all means, feel free to reach out to Rob or Andrea directly.
Thank you, Jonathan.
Thanks.
So moving now to our second panel, and our second panel is on leasing with two of my partners here at Cassels in our Toronto office, Armin and Artie. And so I see Artie that you're there, and I see Armin as well. Perfect. So we'll get going on this second panel with respect to leasing. So diving right into it, Armin, so every license in the cannabis space is site specific, and it's vital to the survival of those companies that they're able to maintain access to their both production and retail spaces. Given some of the short-term cash flow issues that some of these companies are having right now in the context of commercial leases, how are they dealing with this, and how are landlords reacting?
Sure. Thanks, Jonathan. So look, obviously we're facing an incredibly novel situation that, frankly, the majority of existing leases were not designed to address. A typical force majeure provision in a lease, and what I mean by that is your unforeseeable circumstances clause, such as acts of God, that prevent parties from fulfilling their contractual obligations. Those force majeure clauses were not designed to, first of all, specifically outline pandemics. And we know that courts like to see specific language if either party is trying to rely on a force majeure in a lease. And more importantly, from a tenant's perspective, those force majeure provisions, 99% of the time, will expressly carve out tenants' monetary obligations under the lease. So, in other words, tenants will be legally obligated to continue to pay rent under their lease, regardless of the majeure event, including a pandemic. So it's important for tenants to realize that absent a unique tenant favorable provision in their lease, this COVID-19 situation presents, both for the landlord and tenant, issues that'll have to be addressed on a case-by-case basis. Parties are going to have to get creative in trying to achieve, hopefully, the greater good. And generally, as I said, tenants will legally be obligated to pay rent, but absent an agreement by the parties, they're going to be on the hook in that sense. But their best bet, and the most practical advice we're giving tenants in a lot of cases, is start that dialogue with your landlords as soon as possible. Obviously, depending on the size and scope of the deal and the tenant's negotiating leverage, those discussions may happen in an expedited fashion. But there are all sorts of variables, and we've seen, frankly, all sorts of responses. In some cases, landlords willing to cooperate with their tenants, a lot of them understanding that it's not in their best interest for their tenants to go belly up during this time. But in other instances, unfortunately, we've seen the landlord be unresponsive. So it really, again, is a case-by-case situation. But the first step all tenants should take is reach out to their landlords. And be mindful as a tenant that if you're not going to pay your rent during this time, you're potentially giving the landlord the upper hand in certain instances. What I mean by that is eventually, subject to notice and cure periods under your lease, that's going to turn into an event of default, giving landlord its right to exercise various remedies under its lease, including termination of the lease or accelerating the rental stream. So while there are many factors to consider, including the landlord-tenant relationship, the long-term business and public relations considerations, and depending on the location of the lease premises, there may not be an imminent risk of the landlord enforcing its legal rights under the lease in question at this particular time, but that doesn't mean they can't in the future. So considering the current environment, a landlord may have a hard time even finding those replacement tenants. So given the lack of clear legal answers during this time, this novel situation in particular, parties have to look to those pragmatic and proactive solutions to try to address the issues and the cash crunch that tenants are facing. We suspect Canadian courts are not going to look kindly on any hardline approaches taken by either party, nor will they look kindly on required strict compliance of terms, dates, and deadlines under a lease, especially during a time where acting reasonably and equitable is going to be expected. And so, assuming tenants don't have that particular rent relief provision in their lease, which again, in most cases they won't, they can suggest one of the following proposals to their landlords and hopefully get them to the negotiating table to address the current concerns, one of which is a deferral concept, the deferral in rent, whereby the tenant will be relieved of paying its rental payment or rental stream during the COVID-19 situation, but then have to pay it back on an amortized basis over a certain period of time. And of course, that period can be negotiated, and when it starts, hopefully it's set up in a way that it doesn't set the tenant up for failure. For example, having to start repaying on that amortized deferred amounts right away. What we'd like to see is for tenants to be given a few months to ramp up their business before they have to start paying back any deferred. The other option is, of course, an abatement of rent, which is from my experience so far, that's going to be a tough ask. Maybe a partial abatement of rent would be something that could work, perhaps 50%, whereby the parties are essentially sharing the pain during this time. You can propose an extension of your lease term, where right now you get an abatement, but then you extend the back end of your lease at fair market terms. Or perhaps if there's a security deposit being held by the landlord, that's another thing we have been seeing, that tenants and landlords are in some cases willing to work with that, whereby the landlord applies that security deposit to the April and May rent, and hopefully agrees that tenant will not be obligated to replenish those amounts. And of course, last but not least, is taking advantage of any government assistance programs, and in particular the CESAR program, which my colleague Artie will be speaking to shortly.
And so I guess moving to that, Artie, can you tell us a little bit about the Canadian Emergency Commercial Rent Assistance Program and what we know so far and what questions there might still be?
Yeah, definitely. Hi, everyone. Frankly, I wish I had all the details, or at least, more to share. Given the program was first announced back on April 16th, and then further details were released on April 24th, but the government's being tight-lipped. Presumably because they are still working out exactly how the application process is going to work, how the loans will be distributed through CMHC, and how the forgiveness aspect of the loan is going to be monitored in the different provinces. But, the key elements for Ontario is that the government and province have committed $900 million in loans, so it's a substantial amount, and it's really in the form of a cost-sharing program between landlord and tenants, where they'd see the monthly gross rent, so that's both base and additional rent in net leases. The gross rent that tenants would be required to pay for the months of April, May, and June would be reduced by 75%. Now, it's an elective program for landlords, so it's non-mandatory to participate, but those who do would see a revenue stream from their eligible tenants of 25% from the tenants for those applicable months, and then the government would introduce, would contribute 50% of that gross rent. So, and then the idea there is that the landlord would cover the remaining 25% or contribute to the 25%. So that's where the cost sharing comes. Now, again, we don't have all the information, but from what has been released, eligible tenants for this program are considered as tenants that pay less than $50,000 of monthly gross rent per location, per premises, tenants that generate no more than $20 million in gross annual revenues on a consolidated basis up to the parent level. And the other factor, which may be relevant for cannabis producers and retailers, and thankfully maybe they're in a good position to have to consider this, is that the tenants have to experience a 70% decline in pre-COVID revenues or have temporarily ceased operations, so i.e. generating no revenues from the premises. And given the first government order allowing retail stores to continue to operate, and now the fact that retail stores can do curbside pickup and delivery, that's a question that tenants have to consider. So the other factor is that the loans are going to be forgivable if the landlord complies with and meets certain criteria. And the criteria that has been released so far is that the landlord has to enter into a rent reduction agreement for the period of April, May, and June to reflect the 75% rent reduction. And the landlord has to agree not to evict the tenant for those applicable months. There was a lot of conversation in Ontario, particularly when the program was first announced, that the government was wanted to see the landlord forego all profit. It seems like that was just a mis-announcement by the government. They again haven't clarified everything, but it seems like that's not going to be the case. But the program is going to be administered through CMHC, and one of the requirements is that the landlord has to have a mortgage loan securing the property that relates to the lease premises. And I think the idea there is that the loan is going to go to offset fixed mortgage payments. Now, there is a caveat that if the landlord does not have a mortgage loan, then CMHC is going to consider alternative mechanisms to provide the loan to implement. So again, they might be considering offsetting the loan with other fixed payments that the landlord has to make if it's not a mortgage payment.
Perfect. Thanks, Artie. And correct me if I'm wrong, but most of this is run through the landlords, if I'm not mistaken. So for a number of our guests today that are tenants, is there anything that they can do on their end, or is this really just in the hands of the landlord?
Yeah, it's up to the landlord to apply. So what tenants can do, and it goes back to what Armin was saying, is to start that negotiation. When the program was first announced, there was a lot of media attention on it. Since then, it's been a lot of negative attention on it. But I think tenants can make that request. If it's, some landlords may prefer to roll the dice with this program and collect 75% of rent and improve their relationship with the tenant, right? And ensure the tenant has long-term economic viability. I think another important point to note for tenants is that the loan can apply retroactively. So a lot of tenants may find themselves in a position where they've already paid April rent and they may have already paid May rent. But that doesn't mean that the landlord can't still apply for this, get the loan, and then retroactively either refund rent or give a credit for future months. That's all allowed. So, I think this is one more negotiating tool that tenants have, and they should push their landlords if the tenant qualifies.
And just to add what Artie said, on the ground, what I'm seeing is I've had some clients approach me and say, hey, I've mentioned the SESRA program to my landlord, and they've just they're sitting on their hands and not moving on it. What do I do? Well, unfortunately, as we stated, it's really the onus is on the landlord to apply. And in some cases, landlords may be shying away from the application process right now, and particularly because maybe there are still details to be determined on this program. But you can get creative. It's not to say that at that negotiating table as a tenant, perhaps you can offer up paying for a portion of the costs incurred by landlord to set up this program. Maybe that'll help incentivize the landlord to cooperate, but that's just one way perhaps you can urge or incentivize the landlord to go ahead with this program as opposed to, not doing it.
And in Ontario, obviously, over the last call it 6 months or so here, we've seen a lot more activity in the retail cannabis sector as things are opening up from a government perspective. And so we're still seeing a lot of new retail stores that are popping up, new lease negotiations. Given the COVID-19 environment that we're in right now, is there anything that tenants should be aware of as they're negotiating new leases that maybe they weren't considering before?
Yeah, I mean, I think in this environment, there's going to be a lot of attention to operational provisions, right? There has to be thought on, obviously HVAC and air filtration is going to be a critical factor. Producers, they know cannabis plants require particular and exact moisture, light, temperature, air circulation. So fortunately, their premises, are probably, they have a leg up in that regard. But I think, so I think how HVAC is going to work and whether tenants are going to require particular HVAC requirements, whether they're going to have to deal with a premises that needs extra security, how storage and the pickup and delivery aspect is going to work for their operational procedures. I think all that is going to be a lot more important.
And Armin, given the regulatory considerations in the context of a lease, is there anything that landlords and tenants should keep in mind while they're negotiating this from a regulatory perspective?
Yeah, sure. And some of my answers also may overlap with Artie's here, but to briefly summarize, look, when you're dealing with a cannabis lease, there are going to be plenty of landlord and tenant side considerations. I mean, particularly from a landlord perspective, landlords want to make sure that all use and continued operations in their building or leased premises are going to be obviously in compliance with applicable laws and in accordance with all licenses that are issued to the tenant and applicable zoning bylaws. And this can come in a variety of forms in the lease. An acknowledgement or a covenant by the tenant to comply with laws is obviously a standard provision that we always see in leases. Representation by the tenant that it's obtained and will maintain all appropriate governmental licenses and approvals. And as an additional layer to that, to give landlords comfort, they'll add an evidence provision where, upon notice or request by the landlord, the tenant has to provide evidence that it has obtained all these required approvals and licenses. In some cases, tenants aren't even permitted to open for business until they, provide this evidence. And again, depending on the size, scope of the deal, there could be a termination right that landlords want to look to, because if this drags on and a tenant is unable to get its licenses after a certain outside date, and that could be subject to a force majeure. But if after a certain period of time that, for example, retail shop hasn't opened, then the landlords in some cases want an out and they want a termination right. And again, obviously, if the tenant is in a strong negotiating position, maybe that termination right can be mutual. If they were using good faith efforts and for some reason they were unable to get, the applicable licenses. And from, again, from a landlord's perspective, the permitted use clause, it's going to be very important as well, just laying out specifically what the space can or can't be used for. And just going beyond the regulatory perspective, also odors and mold issues become relevant with a cannabis lease. And so, you have to be mindful of these things. There's increased risk of fire in a cannabis production lease, excessive amounts of electricity and water and insurance premiums. Increased insurance premiums can be something that we want to be mindful of. And from a tenant's perspective, of course, look, you want to ensure that the lease permits the tenant to use the premises the way they intend to use it and the way they've been authorized to use it. So obviously, be mindful of any provisions that could hinder you from that sense or from that regard, and also ensure that the landlord covenants that it won't do anything, and that you as the tenant are not obligated to do anything against your legal regime for cannabis. And then again, depending on the tenant's negotiating strength, if the tenant loses its authorization to operate a cannabis business or related business during the term of the lease without the fault of the tenant, for instance, then try to bake in some sort of termination right. Now, in the likely scenario, a landlord's probably not going to agree to that, but at the very least, try to negotiate a change of use clause, whereby if you decide to assign your lease, that the landlord is going to be reasonable in changing that permitted use. Because look, transferability of a lease is a very important issue for all tenants, and you have to be mindful, in particular with cannabis leases, you're dealing with a very tailored permitted use provision that limits the marketability of your lease going forward. If you look to transfer it and if you need to get out of the lease. So having the ability to negotiate a change of use provision can be very useful down the road. And again, I think just be mindful of the force majeure provisions. Going forward, we're going to see a lot more landlords and tenants being mindful of this provision, where in the past it may have been, looked over. And now force majeure is going to become a very important topic of discussion, because what if another pandemic situation happens and, for example, retail tenants are not allowed to access their space? Then what? And so my suggestion is, if you're trying to negotiate some kind of rent relief in your lease as a tenant, get it in early at the LOI stage. Don't just surprise the landlord with a rent abatement or a rent deferral concept when the lease has been issued by the landlord's lawyers. Try to get that discussion to start much earlier in the process with the brokers. And so, yeah, that's...
Yeah, I think to piggyback off that as well, I think alterations and improvements are going to be very important for tenants. I mean, typically landlords want to control exactly what's happening in their premises, right? So the tenant has to go get consent for any work that they want to get done. Well, now in this COVID situation, and I think this applies to existing leases and it applies to new leases, the tenant may want to do more work. They may be required to do more work to comply with employee, OHS matters. They want that flexibility, or they should want that flexibility. So in existing leases, to have to go get landlord consent, the landlord could play hardball there. So I think you have to go and look at what consent is required to do the work. And going forward, tenants, off the bat should try to carve in some opportunities to do health-related fixturing, like installing air filtration systems, like making sure that there is the proper social distancing, to do some of the alterations in the premises that are required. I think will then save a lot of headache later on trying to negotiate and battle with the landlord.
And in line with that, also to Artie's point, just be sure as a tenant also to negotiate what happens at the end of the term. Some of these leasehold improvements you're going to put in the space can be costly, but at the end of the term, landlords are going to demo the space anyways for the next tenant. So try to negotiate that, leasehold improvements are not going to be required to be removed by the tenant at the end of the term.
Perfect. Well, thank you both so much. Unfortunately, run out of time here, and instead of taking a 5-minute break, we'll take a 2-minute break here, just given that we're running a little bit over time, and we'll be back shortly with our next panel. So thank you, Armin and Artie, and we'll be back shortly.
Thank you.
Welcome back, everyone. Our next panel here is with two of my partners in our labor and employment practice, Kristen Taylor and Caitlin Russell. Thank you both for making time for this panel. So jumping right into it, Kristen, obviously one of the hot topics right now for any business across the country is what form of government assistance is available for employers that cannabis companies should be available for, or should be aware of, sorry.
Thanks, Jonathan. So biggest and most significant program, of course, is Canada Emergency Subsidy. The portal for that opened April 27th for applications. It requires a 15% drop in revenue for March, 30% for April and or May based on the same month in 2019, or an average of revenue received for January and February 2020. And where that qualification is met, employers will receive a wage subsidy equal to 75% of what they paid by way of remuneration, to a maximum of $847 per week. Right now, as of this moment, although I'm told it could change momentarily, it is running for the period from March 15 to June 6. And the question that I'm getting asked most often about it is whether employers have to pay pre-pandemic wages or more than what the subsidy actually provides. The legislation requires employers to make best efforts to top up employee salaries to pre-crisis levels, but there isn't a reduction in the payment and there isn't any penalty if participating employers aren't able to meet that standard. So, and then as I say, last Friday, Prime Minister Trudeau said the program would be extended beyond June 6th and that we would hear further details this week. Earlier this week, the employment minister suggested it would be extended by a matter of months, but we still don't know the exact length of time, and I understand that that is subject to negotiation. And just informational only, I thought this was pretty telling, but as of May 7th, so last Thursday, 97,000 Canadian employers had applied for over 2 million Canadian employees. So it is being accessed a lot. One of the other programs I think important to note that I have a lot of clients asking about is the EI WorkShare program. So that's Employment Insurance WorkShare. It's designed to minimize layoffs by paying EI benefits for the days of the week that an employer is unable to provide work to employees. And it applies where the reduction is between 10 and 60%. That program has to run for at least 6 weeks, but can now run to up to 72 weeks. So they've extended the duration potential for that program. There are a number of hoops that have to be jumped through in order to actually qualify and to be approved. And your employees have to agree to participate. But something certainly to consider where there is work that can be shared but isn't a full load for any employee. And then the last one specific to Ontario employees I just wanted to highlight is through the Workplace Safety and Insurance Board. At the end of March, they announced that they're prepared to defer premium payments for 6 months in 2020 in light of the COVID-19 crisis. So those are the three I wanted to highlight, pure employer-related programs.
Great, thank you, Kristen. So kind of pivoting from government assistance a little bit, Caitlin, what considerations need to be taken into account if companies are looking at temporarily laying off some of their workforce?
Right. So layoffs in Canada are distinct from a termination of employment. Sometimes the language gets used interchangeably, but a layoff is a temporary suspension of active duty where the employee doesn't come to work and is not paid, but they will be entitled to collect EI or the Canadian Emergency Response Benefit. They can be a good option right now for employers because it essentially allows you to reduce salary costs without triggering termination and severance entitlements right away. The rules around layoffs are set out in employment standards legislation, and they can vary quite dramatically across the provinces. So it's important to get jurisdiction-specific advice if you're considering a layoff. In Ontario, for example, the ESA permits layoffs up to a maximum of 13 weeks, which can be extended to 35 weeks if benefits are continued over the layoff period. And if the employee is not recalled to work within those timeframes, that's when their employment is deemed terminated and they'll be entitled to termination and severance payout. So it's important to keep track of the timelines applicable in your jurisdiction and recall employees when you can before the temporary layoff period is up. Just one last thing I want to mention. There's been a lot of information out there that layoffs are illegal in Canada, which in my view can be a bit misleading. There are cases that have found that unless your employee has a contractual provision in their contract that permits them to be laid off, that they may claim constructive dismissal, which essentially means that in response to a layoff notice, they could treat it as a deemed termination of their employment and seek termination and severance entitlements. That being said, we really don't know how courts are going to treat a layoff in the context of a global pandemic. So we're not sure if the same case law would apply. And also, even without a contractual right to lay off, employees can agree to a layoff. And in most cases, that's what we're finding is happening. Right now, employees are looking to retain their jobs, and many are accepting layoffs even where they don't have that express contractual ability on the employer to implement it. So in terms of reducing constructive dismissal risks, there's a few things that are important to consider. If you can, you should provide advance notice of the layoff and continue benefits over the layoff. And also, in terms of communicating it, ensure that it's clear that it's a temporary measure and that it's in response to a global pandemic. And we find with that messaging, employees are much more willing to accept the layoff, and constructive dismissal claims can be minimized.
Thanks, Caitlin. In terms of some other options for employers, Kristen, what should companies be thinking about in terms of wage reductions or salary or hourly wage reductions?
Yeah, so this has become a common tool as well, where you continue to need people. So it's not a temporary layoff scenario where you actually don't have work to provide. But interestingly, the same risks apply that Caitlin's just described in connection with constructive dismissal, although the risk is less than what it would be in a temporary layoff because you're still providing some pay, obviously. So 10% reductions, we're generally not concerned about. Not going to raise a constructive dismissal issue. Pretty well accepted across Canada that something in the nature of a 10% reduction in total comp, not going to trigger constructive dismissal. The deeper the cut goes, obviously, the greater the risk. Cuts more than 50% will actually be considered a temporary layoff. So those restrictions in terms of how long they can last for that Caitlin just described, very important to get province-specific advice on. And then the same best practices that Caitlin's talked about also apply here. So important to provide a timeline so that it does look to be temporary and not permanent. Tie it to the pandemic and the impact on the business. And then I've got a number of clients who've gotten quite creative in terms of how they're making these cuts. Some of them are coming up with a grid. They're protecting their lowest income earners, and the percentage of the reduction will be tied to how much you earn. Many are also hoping to repay some or all of the cuts when things return to normal, whatever normal is going to look like. And then I have some clients that are actually developing metrics that are associated with not only when original wages will be restored, but also if certain metrics are achieved, whether they'll be able to pay back some of the cut that employees have taken to get through the crisis and support their employers.
That's great. Thank you. And so, Caitlin, kind of transitioning from the element of dealing with employees that from a cost perspective, shifting a little bit to the workplace health and safety. What are some best practices for businesses that are deemed essential right now and that are still open?
Right. So it's important at the outset to remember that every employer has an obligation to ensure the health and safety of its employees. And this includes obviously implementing preventative measures that are going to reduce the risk of your workers being exposed to COVID. Those measures are going to vary depending on the nature of your business and your workforce. But as a good first step, to ensure protection of workers and to reduce potential liability down the road, it's important that you're really closely following all public health and safety recommendations. And there's a lot of information out there right now. So we typically recommend designating a point person or establishing a committee that can follow those recommendations, report them to key decision makers, and ensure they're being implemented in the workplace. The Ontario government has recently released some workplace safety guidelines that pertain to specific industries. We didn't find them overly helpful, but they do provide some good general information on best practices right now. You're also going to want to ensure that you're properly communicating the measures you're taking to employees. So they're really looking to their employer right now, for reassurance and guidance during this time. And so you're going to want to implement the measures that you're taking in either a policy document or some sort of information page that they can access regularly. Basic recommendations that should be followed in virtually all workplaces right now. Obviously requiring employees to disclose any flu-like symptoms or contact with anyone with COVID-19 and to self-isolate for the 14-day period. You should already be restricting non-essential business or personal travel. Putting in place measures to reduce contact between employees and employees and customers. You should still be allowing employees to work from home for those roles that can be performed remotely and ensuring proper sanitization. And then beyond that, you need to kind of do an assessment of your workplace and determine what additional measures you may need to take. Some of the measures that we've seen clients implementing include, managing traffic flow within the workplace, staggering shifts, start times, break times to reduce the amount of people that are in the same place at the same time. If you're manufacturing, you want to be eliminating or minimizing, shared equipment between employees, potentially installing barriers or partitions. There's some talk in the leasing seminar as well about new ventilation systems. There's also measures such as personal protective equipment and temperature screening that in some workplaces may be warranted. So it's really going to depend on kind of the nature of the business, and you need to really assess the specific risks that your workers may be exposed to. I should note there are some privacy and human rights considerations with some of those measures, particularly temperature testing. So, we do recommend implementing those carefully and in accordance with legal advice. And there are some best practices around those that can reduce potential complaints from employees, including, using a lower intrusive screening measure, testing kind of on a non-intrusive schedule, and ensuring that you're not retaining personal health information of employees, except when you need to justify them leaving the workplace. So again, those more kind of extreme measures as they may be seen right now should be implemented with legal advice, but to the extent that they're necessary to protect your workers, our view has been that they can be warranted in certain circumstances.
And Kristen, as we start to think about as certain jurisdictions start opening back up and some of the return to work planning that's going on, and it's a normal topic of conversation for you, especially heading up the Cassels internal discussions and all of your clients as well. But anything in particular that our clients should be thinking about?
Yeah, so for organizations who have been working remotely or who've been shut down completely and haven't been working, I do think that there are some kind of critical issues, and Caitlin's given you a pretty good overview of some of the considerations for, because what has applied during this crisis is going to continue to apply as we open back up again. And I understand we should be getting details about that as early as tomorrow in Ontario. So important for employers to remember that their obligations are in respect of the workplace. So what employers don't control is the employee's commute to work. And that commute can even include, an elevator that whisks you up into the workplace. So those are legal obligations that do not attach to employers. They are still going to be considerations, though, in terms of getting your employees to a comfort level of returning to work. And based on what I've seen with essential workplaces, you're probably going to have to deal with three buckets of employees, if you will. Those who are immunocompromised themselves, who've had exposure to COVID-19, who are concerned about their own personal health and safety. And then the second bucket would be those employees who are living with individuals who are immunocompromised, or healthcare workers if they're not self-isolating within their home, or who have other family obligations that are going to prevent them from returning to work. And then you're going to have everybody else, many of whom will be fearful for their safety. It's more of a generalized fear. From a legal standpoint, that's not going to justify refusing to go into work, but is going to take a lot of education on the part of employers. So in terms of things that you can control, the physical distancing is going to be absolutely critical. Pretty easy to remove chairs from a conference room, but what do you do about the rest of your workplace? Do you need to install plexiglass barriers? Artie had mentioned the airflow issue. I think Caitlin mentioned it as well. Actually knowing how your HVAC system works is all of a sudden become very important. Who'd have thought? Cleaning and best practices for hygiene are going to be critical. What are the touch points? How often are you going to do deep clean? Can you minimize or eliminate access to supplies, coffee machines, fridges, photocopiers, all sorts of what used to be minor little things are now going to really have to be well thought out. And then Caitlin highlighted a couple of the privacy kind of things. So one of the things that I've been working on with a lot of clients right now are questionnaires, trying to balance privacy and safety, but ensuring that people who are sick actually stay home. So now is a good time, if you haven't already, to review your sick pay policy, because you don't want to incent people to go to work sick. You want to make sure that they actually stay home. And then the questionnaires, I have some clients using them on proposing to use them on just the return on a daily basis at the other end of the spectrum, and on a weekly basis in some cases, because they want to know, what the risk of the exposure is on the part of the employee. They want to know who they've been in contact with. And, a lot of that is going to have to do with the employer's obligation to be able to trace, if somebody tests positive, what that person and who that person has interacted with, because that's going to become a critical thing for employers to be able to deal with infections in the workplace, particularly as, the government seem to be getting more aggressive about all of us getting back into the workplace. And then the PPE, the personal protective equipment, is always a last resort. That's should only be used for employers who've done everything else they can do to make the workplace safe and still have concerns. There may be certain jobs that will need it. There may be certain times of day, entry and exit to the workplace, for example, commuting, those kinds of things. But if you're requiring it in the workplace, you're going to need to provide it. You're going to need to have rules about how it's used, how it's disposed of, all of those things. So that person who may have been doing some planning as we were going into this crisis and getting everybody out of the workplace is going to be very busy on the other end trying to figure out a staged return. And I think it's a heck of a lot more complicated as we go back, and employers are going to have a real obligation to educate their employees and assure them of their personal safety in order for this to work.
Perfect. Well, thank you both for all that information. Unfortunately, we're out of time on this panel, but if anyone has any further questions, Kristen and Caitlin's contact information is on the screen and will be sent around later. So thank you both very much. And we'll move on to our final panel of the day, which is a topic of conversation that I think most companies do not want to have. And so something that we wanted to address with the audience today and talk about how you can best protect yourself in the event that you do need to pursue some form of restructuring transaction. And so my partners, Jane Dietrich and Lance Williams, Lance is based out of our Vancouver office and Jane in our Toronto office, have joined today for this panel with respect to restructuring options in the cannabis space. So thank you both for making some time. And to kick this off, Jane, maybe you can just talk about what options do companies have as they start running out of capital to fund their day-to-day operations.
Sure, thank you, Jonathan. So I guess the first thing that companies should be thinking about is what are their long-term goals and do they have the short-term funding to get there? So is there a long-term change in the business that's required, or is it simply a blip? If it's a long-term change, which in many situations it may very well be, is it a requirement for additional capital investment? Are there assets that can be sold to streamline that weren't core assets, or they're part of the business that can be sold? Does the entire business need to be sold? Those questions really need to be asked. And then on the other side of it is, as a long-term goal, if the business can be, healthy in the future, is it a matter of going to your creditors and asking for a compromise of some kind? And we talk about them as plans or proposals. And what the restructuring law permits essentially is you can put anything into one of those plans or proposals that you would in a contract with your creditors. But rather than getting every single creditor to sign the bottom line agreeing, everyone is bound if there's a vote of a double majority. So if 50% in number and 66 2/3 value plus, if that minimum amount votes yes, and the court says it's fair and reasonable, then those compromises can be forced on the holdout creditors. And those compromises could include anything from, maybe I owe you $100 today and I can't pay you now, I'll pay you over time, I'll pay you a reduced amount, I'll put a pot of money up and everyone can get their share. And so there's limitless possibilities of what you can offer to people, but it's a matter of binding them. So when you think about what those long-term goals are, maybe it's a sale, an investment, and some combination of those, then the question really becomes, do you have enough short-term cash to get there? In the insolvency restructuring world, that question is very important because courts won't permit a company to come in and take advantage of some of the unique features of restructuring law if you're not able to satisfy what we call the post-filing creditors. In that regard, there's the ability under our statutes to ask for additional funds on a priority basis. So even if you have secured creditors out there, or if you have certain assets that are undersecured or free, some real estate, equipment, inventory, whatever it may be, to ask for new financing to come in, but to prime all of the existing claims, secured or unsecured, and be paid out first. And so in some respects, that new money in is the safest. Once there's a court order giving it priority, it gets repaid first. And there are a number of lenders who play in that space. And so it's important to see if you need that funding to try to identify those options, either from your existing secured lenders or from those lenders who play in the space, so that you can have the short-term funds necessary to get to your longer-term goals.
Great, thanks, Jen. And so Lance, can you describe what's the difference between a plan under CCAA versus a proposal under the Bankruptcy Act? And do they ultimately accomplish the same objective? And why would a company choose one over the other?
Sure. So probably best to start with, they are very similar, and certainly the intention of Parliament when it last amended the Bankruptcy and Insolvency Act and the Companies Creditors Arrangement Act was to try and make them interchangeable. It didn't really work, like many government attempts to do things. So both are debtor in possession regimes. So both are the scenario where the debtor remains in control through a supervised process. Both allow a compromise with creditors, as Jane mentioned, with the double majority concept. And both have a similar regime with a stay of proceedings, allowing you to get certain court-granted charges, including borrowing that Jane mentioned, to run a sales process for all or part of the business. But there are some pretty key differences. To qualify for the CCAA, you need to have more than $5 million worth of debt. And you make your initial application for basic relief. The court can grant you a 10-day stay. You then go back for more extensive relief after that. And the discretion of the court and the ability of the court to customize relief to fit the situation is extremely broad. And so we see a lot of creative things done in CCAA. Under the Bankruptcy and Insolvency Act proposal regime, it is much more rigid. It is much more a statutory-driven process. It is easier to get into. It involves filing a notice of intention to make a proposal, which can often be done in a couple of days. That gives you a 30-day stay of proceedings, so your creditors can't take any steps for 30 days. That can be extended in increments of up to 45 days to a maximum of 6 months. So there's a hard stop on how long your proposal proceeding can run. As I indicated, you can get the same charges that you would get in a CCAA for some things. So professionals, borrowing, those kind of basic charges, but you don't get the creative steps for other things that you can often get in a CCAA proceeding. The other disadvantage is you end up with the Office of the Superintendent of Bankruptcy involved, which adds another administrative layer. And in general, you're just in a much less flexible regime. The result being BIA proposals are good for smaller entities and very straightforward ones. The minute you're getting into more complex type of regimes, you're often better in the CCAA just due to its flexibility and the discretion of the court to fashion a remedy. The one exception I would add, and I won't go into any detail on it, but is if you have issues with a landlord that you need to compromise, there can be some advantages under the Bankruptcy and Insolvency Act that don't exist under the CCAA.
And so for a company that's worried about where they may be able to get their next financing coming from, when's the best opportunity for them to start having that conversation? Is there a point that's too early that they should be reaching out to start that, or is there additional protection by reaching out early?
So I think the options that we have to help a company are multiplied the earlier they come. And a lot of that has to do with people are putting more cash into the company in some shape or form to keep things going at certain points, and having the cash structured on the way in a thoughtful manner, be it secured debt or otherwise, can provide a number of additional options on the way out, or when you get into CCAA or other types of insolvency proceedings. It can provide control and can open up the possibilities of how you can structure a plan or investment later. I think one of the other things that we often see is sometimes people make kind of snap decisions about paying people more, or taking money out, or paying certain creditors in preference to others. And those type of decisions can attract personal liability for the directors of the company in the right situation if you were to ever go into insolvency proceedings. And it's important to at least understand what those risks are, because some of the look back periods can be up to a year or potentially 5 years. And so you want to understand if you're, by making these payments in that fashion, or paying retention bonuses to certain key employees, are you doing it in a way that's defensible later on, or will it attract additional liability for you?
And so, Lance, what are some of the protections that a company would get under either a plan or a proposal?
So the kind of general overarching purpose of the regimes is to put you in a better position to not be in a panic mode. This kind of ties into what James said about making panic payments to creditors or trying to deal with things in a disorganized fashion. So the big item that you get out of both the proposal and the CCAA regimes is a stay of proceedings. So creditors are stayed from taking any action. And the idea is to deal with everyone in one proceeding in a rational manner. So you get the stay of proceedings, people can't cancel contracts, people can't start taking action individually, there's the legal action stopped against the company. Parties can go to COD, nobody can be compelled to extend credit, but you can still get services supplied. Where you don't have an agreement, you can have parties declared a critical supplier, which mandates that they provide supply to you. Of course, you have to pay for it COD generally, or there would be a charge granted. Other protections is some priority charges can be granted in terms of the financing. If you do a key employee retention program to keep your employees around with some sort of bonus if they stay with you through the restructuring, that can often be secured. An administration charge to cover professionals that need to be engaged in the process, and protection for directors and officers, which I think Jane's going to address, are all available. And of course, the best protection is your creditors can't do anything until either, obviously the process can fail, but if it's successful, you do a compromise or a sale or some combination thereof to get you out the other side and the business continuing in some way without parties being able to take in self-help remedies and depleted value that way.
And so Jane, I'll pass it over to you just in terms of the benefits for directors and officers.
Sure. So directors and officers have a number of liabilities, personal liabilities associated with just unpaid wages and certain unpaid taxes, source deductions, excise sales tax. So there are certain obligations of the company which they are liable for as a matter of law. But there are also, in the time period leading up to an insolvency, if there are what we call reviewable transactions, transfers at under value of property, directors can also have liability in that respect. A couple things that filing for insolvency protection does. One, it stays any action against a director or an officer. And so even if that's a misrepresentation lawsuit, whatever it may be, there's an initial stay of proceedings protecting not only the company that Lance talked about, but also the directors and officers. In a CAA proceeding, the company there's a court-ordered indemnity where the company grants an indemnity to the directors for any post-filing liabilities. And then there's a charge or a priority lien granted on the assets to secure that. So where, leading up to the CAA protection, for instance, if there are unpaid wages, directors would have personal liability. If those unpaid wages happen after a CAA filing, there is priority granted under the court orders to protect the directors. And then I guess most importantly, at the end of the day, if you can get to the spot where you do a plan that's voted on and approved by the court and the creditors, the vast majority of those plans contains comprehensive releases of directors and officers of any type of liability associated with the company, which is critical in protecting your directors and officers.
Certainly a major benefit of any of these types of proceedings. Just being cognizant of time, I wanted to make sure we hit on one particular question. And so given the number of cannabis companies that are listed on the CSE that have US operations, and given the limited US bankruptcy protections available under US federal law, Lance, are there options available for these companies that are listed on the CSE that are operating in the US, have a Canadian parent company, but not much else going on here in Canada, that they can leverage Canadian bankruptcy protections?
There are. The US regime, with it being legal in states, illegal federally, leads to a bunch of basically confusion in how US law is going to be applied, because bankruptcy law is federal in the US, but there are certain state protections that are available, and they vary wildly state by state, involving stays of proceedings, etc. So in the US, companies that are listed in Canada can seek protection in Canada. And the concept that is generally applied is, where is the center of main interest, the COMI. For entities that have really nothing in Canada other than their listing and an incorporation, you run the risk of that being challenged. We haven't seen that happening, though. So, and most creditors are cognizant of a proceeding being better than a piecemeal enforcement. So having the listing in Canada is generally, and the parent company incorporated, is generally sufficient for the court to assume jurisdiction. If it got challenged and it was truly there is nothing in Canada other than the parent, there is a risk there of Canada being determined to not be the center of main interest. But if you get over that, which seems to be happening, what can be done in the US? There's a variety of remedies available or that people believe are available. So you can, in a normal scenario, you can get recognition of the proceeding in the United States. You file the entire corporate group in Canada, and you can get some sort of recognition in the US, what's called a Chapter 15 proceeding. Under a technical reading of the law, that's not available to cannabis companies because cannabis is illegal federally in the US. Chapter 15 is a federal statute, the US Bankruptcy Code, so you can't get protection. There are a number of judges and academics that have suggested that may not be the case. In the right scenario to challenge that in the right court, we may see that protection extended so that Chapter 15 may be available depending on the ultimate court ruling there. In the interim, where we've had to look at this for parties, we've looked at state remedies. So there are looking at what state they operate in and what local remedies are available in terms of getting a stay of proceedings and preventing creditors from acting at the state level. There's also the problem that most of the insolvency professionals are not prepared to take control of any assets generally, but certainly not US assets. And Canadian insolvency professionals are unwilling to cross the border for the purposes of a cannabis operation. So other protections that can be looked at are engaging personnel in the US to assist with, in a scenario where management may not be available anymore, so where management has resigned, or there's been some kind of enforcement, getting a restructuring officer in the US to take control and operate without commencing a formal proceeding. All of those have been looked at. We haven't seen any of them fully play out yet to see exactly how they're going to work. What we have seen thus far is, I believe it's Diomemed, a receiver was appointed over the Canadian entity, who then is going about selling the shares in the US entities. So that was an enforcement mechanism that allowed the sale of the US entity through Canadian insolvency proceedings without actually engaging the US. Other restructurings thus far that have had US operations, I'm thinking particularly of Ascent Industries, management stayed in control. So the court was able to fashion the protection of allowing the Canadian entities and a couple of the US entities to file for protection. The court oversaw the process. The US entities that were not part of the filing, that required funding to continue operations to maintain enterprise value, the court very closely monitored the payment of funds to those US entities, but it did allow it on the basis that allowing money to fund the US to run, notwithstanding it was running outside the proceeding, making sure it was closely being monitored by the court-appointed monitor and the court, and there was frequent reporting, that added enterprise value, and the court was willing to work around it to deal with the problems in the US. So that was a very long-winded way of me saying there are a bunch of remedies available to deal with the US, and while they haven't fully been ironed out, there's been a lot of commentary on this area. So there is relief available to Canadian listed parent companies that allows them to deal with the US. And really doing an analysis of who the creditors are and who the secured creditors are becomes key in determining what kind of structure will ultimately work for the cross-border.
Thank you very much for that. I know you both have been quite busy on the Canadian restructuring files that have been made to date. So thank you very much for taking your time, sharing your insights. And so with that, we will conclude our webinar here. And thank you to everyone for joining us here today. Thank you to all of our panelists for your insights. For any of our attendees, if you have a desire for further information, there's a contact box at the bottom. If you put your email address in there, we will be sure to reach out to you and provide any answers to questions that you might have about the topics that we covered today. So thank you again, and we look forward to seeing all of you sometime soon.